Make too much noise. Way too much noise.
Hi, Mr. Weeks, how are you?
Just peachy. How about you?
Oh, watermelon. One, two,
Not
three,
here
four,
again?
5, 6. Miss Norfolk?
Oh, she's not here either.
Is Miss Northfleet out today?
Pardon me?
Northfleet out today?
Yes, ma'am, yes, ma'am.
Right.
She mentioned that last meeting. I don't have any information about Mr. Kramer, though, so.
Okay.
But Mrs. Norfleet did make mention to us that she would not be in today's meeting. She's
Out of town, Julie. She's gone out of town.
It's 2 o'clock. The code board for the city of Tarpon Springs is called to order. If you have cell phones, please silence them. Bobby, call the roll, please.
Miss Wade,
Present.
Mrs. Archer,
Here.
Mr. Weeks,
Here.
Mr. Kramer is absent, Ms. Norfleet's absent, Mrs. Telliar,
Here.
Mr. Perfidio,
Yep.
Mr. Stammes.
Here.
That completes your roll call.
Thank you. Our board attorney will give the invocation and lead us in the Pledge of Allegiance.
Our Heavenly Father, we seek blessings on the tasks before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We pray that our work this afternoon will find favor in your sight. This we pray. Amen. Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of this board is as follows. First, the city presents its witnesses and exhibits, after which the alleged violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits. Then the city can question the alleged violator's witnesses. After both rounds of testimony, both on the part of the city and on the part of the alleged violator, each party is asked to give a brief closing statement, first by the city and then by the alleged violator. After those 3 steps are taken, this board will close the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public meetings, we will have all potential witnesses stand and be sworn in by the secretary of the board. Sir, are you presenting today? You're going to present testimony? Yes? Please stand, and she'll swear you in.
Do you swear the testimony you're about to give us the whole truth and nothing but the truth?
I do.
Thank you.
Again, if you have a cell phone, please silence it. First item on our agenda today is 21-800000107, 743 Sunset Drive, John Durso. Is anyone here for that case? Yes, sir. If you'll come down, first they'll present, then you get to ask them questions. Then you present, and people ask you questions. Do you have any objection to the evidence that she has being submitted into the record?
No, I just had one question. I was
You come on up to the microphone, Mr. Durso.
I was going to ask for an extension. I was away for a while, and some of the stuff that I need is at the courthouse down in Clearwater.
I did not hear.
He wants an extension.
I believe he's, actually the proper term, I believe, is that he wants a continuance and not to be heard today. Is that correct, Mr. Durso?
Yes.
I need some advice on that, Mr. Trask.
So, a motion for continuance could be made in writing, or it could be made verbally. It's being made verbally here today, so you can determine whether or not that you want to grant the continuance. I haven't heard any reasons why at this point, other than something is at the courthouse. You may want to delve into that a little bit further, but ultimately, Madam Chair, you get to make the determination whether you want to continue the hearing or have it proceed as it is listed on the agenda.
Okay.
You need to make that determination.
What was your thing at the courthouse? I couldn't quite understand.
One of them was about the permitting for the shed. I thought all that stuff was here in the city hall, but it's down at Clearwater.
All right, I think we'll go ahead and hear the case.
Okay.
And then we'll find out, and if you need a certain amount of time, we have the ability to give you some of that in our rulings. So let's go ahead and start, and then we'll make that determination later. Because we want things to get moving along and things to be corrected, not to just keep postponing. That's part of what we do. Go ahead, thank you.
Okay. My name is Beth Hughes. I'm the FACE certified code inspector for the city of Tarpon Springs. This is for case number 21-800-00107 for 743 Sunset Drive for Mr. John Durso, property owner. Exhibit 1 are all the photographs. Exhibit 2 are all the notices to include the notice of violation and notice of hearing. Exhibit 3 are the administration documents to include the case summary, property appraiser, and tax collector records. Exhibit 4 is the affidavit of posting and the copy of the sign. Brian?
And I believe we confirmed, Bobby, that he had no objection to those being submitted, and will do so.
Yes, ma'am.
And I believe you don't have the script. You have an old one? Okay, so we have had contact with the owner, Mr. Durso, and on February 23rd, 2021, we conducted the initial inspection. My inspection results were the recreational vehicle on the east side is not 2 feet from the property line. Many items in the backyard were not being stored properly, so there was what would be considered debris. The shed was dilapidated and needs to be properly repaired. Some of the trees in the front appeared to be dead. I did verify with the arborist that some of them were in fact dead. On February 23rd of 2021, the notice of violation was mailed and the green card was returned, signed. Thank you. On February 28th, 2021, we received an additional complaint. On March 22nd of 2021, we mailed an amended notice of violation, and it was returned unclaimed. The reason we sent the amended notice of violation was Mr. Durso had requested more time, and we had granted it. On May 3rd, 2021, a reinspection was conducted. I attempted to contact the property owner to conduct the inspection because some of the items are in the back. I failed to mention the initial inspection. The complainant at the neighboring property is how I was able to view the violations that were in the backyard. Because we won't trespass onto the property is the reason that I had attempted to contact Mr. Durso to schedule a day and time that we could schedule the reinspection. The only thing that I was able to verify was that the jet skis parked on the side of the house were no longer visible. I believe the dead trees still remained on the property, and Mr. Durso did not set up a day or time for me to verify compliance of the remaining violations. On May 17th, The notice of hearing was mailed, and, on May 17th, there was another reinspection. The dead trees in front still had not been removed, and the reason there was another reinspection is we had had two different timelines. We had requested that in the amended notice that the debris and the dead trees and the parking of the RVs had one deadline, and that we had extended the compliance with the dilapidated shed to a later deadline, and that's why there's two inspections in a row. So on May 17th, I did the reinspection. The dead bushes or trees in front had not been removed. The jet skis that had been on the side had been moved. There was now a boat there. However, it did appear to be 2 feet from the property line. The building department at that point had not received any permit applications for the shed, and the property owner had been emailed to an attempt to set up an appointment to verify the remaining violations were in compliance. And Mr. Durso did not set up a date and time for another reinspection. So on May 17th, a notice of hearing was mailed, and the green card was returned signed. On May 28th of 2021, the sign was posted, and the affidavit of posting was signed. So on June 8th, after 5 p.m., I conducted a final inspection. Let's see here. I verified at this time that the dead trees had been removed. The jet skis on the east side were moved, as I stated before, and there was a boat there that does appear to be 2 feet from the property line. I was unable to verify if the debris was removed from the back or stored properly, nor if the shed was repaired per the building official's instructions. So let me go ahead and bring up the pictures. Okay, so this is the shed that's in the back. To me, it appears that it's, the reason I had that it was dilapidated is that it appears that it's rotting. Parts of the board, you can tell that the door is rotting. It appears to be rotted all the way up to this location. There's plyboard that's been slapped on the bottom. It doesn't appear that the portions on the bottom are rotting, and of course the roof is rusted. Let's go to the next picture. I wonder, Mark, can I close? It's hard to see these pictures with the light. Can we close the blinds? How do we close the blinds? You can't see the pictures very well. Thank you. I think so. Can you guys see those okay now? Better? I know when we were doing with the Zoom, they showed up clearly. This was making a kind of... Okay, so anyway, again, this is the shed. Another picture of the shed. There are 3 dead trees in the front. These are just some of the debris. You can see there's a pile of bricks, just a pallet on the side, ladder, some kind of, I don't know what that equipment is leaning against the wall, some tanks. There's more items strewn around the property. Here's a better picture. Oops. Okay, so here's a better picture of the shed. You can see where the sides are rotting. You've got just I don't know if that's just extra metal fence that's sitting in front. Of course, dead palms and vegetation behind the shed. And again, you can see the condition of the side of the shed there. trash cans in public view, a pallet leaning against the house. Again, the trash cans in public view. And that's it for pictures. Okay, so as it is right now, what I would like the code board members is to find the property in violation of 8-52, the nuisance prohibitions, in violation of City Code 8-40, the duty to maintain private property because of the condition of the shed, and also City Code 42.00 for the parking and storage of recreational vehicles, only because I have not been able to confirm that everything is parked correctly, because I have not been allowed to re-inspect the back of the property. Just a side note, and the reason I'm putting those three and not the others is the others are pretty much in compliance. And depending on whether Mr. Durso repairs the shed with permits necessary or is able to do the repair and maintenance without the necessary permits, is the reason why I'm not citing 6-1 or 105.1 right now, because he may be able to repair it without having to get a permit. So again, I'm only asking for 8-52, 8-40, and 42.00 to be found in violation. And that concludes my testimony.
Mr. Durso, you get to ask her just questions at this point and then make your case. Do you have questions for her?
A couple. In regards to the trash cans,
Will you be sure to speak right into the microphone? I'm old, I don't hear so good.
in regards to the trash cans, has there ever been a violation written up on the property for the trash cans?
This one, it was initially written for them being stored in public view, but they are in compliance, and I'm not asking for that to be found in violation.
Right, but you still wrote it up, right?
Yes, I did.
Okay. Could you read this to the board? There's a violation 31520 that was written up for the trash cans in the front. They were moved to the side of the house, which was approved, but now you don't approve of it. So are we basing this on fact of law or opinion?
You realize
I
that
don't know what
that's
you're
not
talking
part of
about.
the case today, right? The trash can she has removed.
She's removed it.
She didn't cite you for that today.
Okay, and which three are left?
8-52, 8-40, and 42.00.
Which consist of,
The debris, oh, I'm sorry, ma'am.
that's okay, no,
I'm
go ahead.
jumping in.
He said, which
Are
are
you okay
those?
for me to
Yep.
answer? 8-52 for nuisance prohibitions, 8-40 for the duty to maintain private property, and 42.00 for parking and storing of recreational vehicles, and again, only because I haven't been allowed to
Right.
verify they're in compliance.
When you say recreational vehicle, what do you mean?
I can read you the definition of recreational
No,
vehicle.
I asked you what you meant by it,
Well, what I mean is by what the code says, so I can read
by
that to
what
you.
your opinion of it is, because you already testified that they're away from the fence, so why is it still a violation?
Because I don't know where they are now, or if they're still there, or if the
But if they're not by the fence for the original complaint, then they're not in violation. Am I correct?
I don't know because I haven't been able to see your backyard, sir.
You just testified that they weren't against the fence.
Correct.
So if they're not against the fence, they're not in violation.
I don't know where they're parked now, so I don't know if it's in compliance or not. It could be on the other side against the other fence. I don't know that. Or they could be removed and you could be in compliance. So as soon as I can be in the backyard, I can verify that.
Do you think my backyard is my private space and my property?
I'm not sure what you're asking for that.
That's- Have you received a complaint on 11/7/2018 about the debris in the backyard?
We're not dealing with other people's cases or yards. This is only about you.
It is my case. It's a picture of the property in the same condition it is today. Never been a code violation, never been an issue with any code enforcement.
Is the picture you have of your property?
Yes.
A
With the
different
date and the
a
picture of the-
different property than we're addressing here? We're only addressing 743 Sunset.
That's what this is. 743 Sunset Drive.
I'm sorry, could you repeat the question? I'm not sure what you're asking.
Have you received the code violation prior for the debris that's in the backyard?
You have many prior code violations that have come into compliance. I don't know the answer to that. I'd have to look.
Could you look at this and tell me if it matches your pictures to the debris that's in the back?
Did you take that picture? Did the code?
That's actually from the surveillance cameras.
Oh.
And it can't be altered or anything. It has a time and date stamp right on them.
This has not,
That was-
Yeah, this doesn't have anything
Yeah,
to
it
do
does.
with the
It has
previous
absolutely everything to do
condition.
with it.
sir,
This stuff is,
at this time, we have no way of verifying this evidence, and this is not the time to be presenting additional evidence. You're asking her questions. If you finished with that, then you can present your case. Do you have further questions for her? Just questions. Who,
okay.
what, when, where, why,
Have you
how?
received any other complaints from the neighbor about debris or stuff in the front of the yard?
Have I ever received
Yeah, that it
complaints?
was written up for.
There are two, we've received, I believe, 2 or 3 complaints for this property.
Yes, she says.
What I'm trying to.
2, from 2 different people.
Okay. What I'm trying to establish with these photos that clearly shows my property, you could see the timeline from the video and the pictures.
Have
and
you, if you've finished asking questions, then you get to present your
Okay.
case.
I guess I'm done.
Now, Mr. Trask, it looks like he's got evidence to present. Would you like me to look at that and decide if that can be admitted?
So if he's going to present evidence, he should show it to the city and determine whether or not they have any objections. If they don't have any objections, then you should just receive it.
Thank
If
you.
they do have objections, you're going to need to hear from both of them as to, whether that objection should be sustained or overruled.
Okay.
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 It's your turn, Mr.
Yes, please.
Mr. Durso. Would you like to make your case, please? And if you
Yes.
have evidence to submit, the city
I do.
gets to look at it first.
Okay. Which would you like me to present first?
You'll get that for you.
Okay. This one, and this one. And this one. And one more.
And Mr. Durso, what are these pictures of?
The one you see of the front yard with all the debris in it are nuisance vehicles. I think it was written up for, because I couldn't determine what you meant by RVs and vehicles, but if you notice the time frame, the neighbor literally waits for me to move something in my yard and then goes, takes a picture and complains to code enforcement. And of course, it's going to be a violation, but it's only within a matter of hour and a half. And it's a consistent problem I am having, which is very well known through code enforcement and the police department.
So I'm sorry, let me go one by one because I'm not, so this one with the car, 2 cars in front, and then your truck behind the trees?
And then him on the bottom taking the pictures? Is that the one? Yep.
And there are dates and times on all of these?
Yes, and it's
Okay.
timestamped from the vehicle.
Okay.
All this one is just showing how he's going out of his way, with the car almost hitting him, just to look in my yard to get a violation to call up. I'm just trying to establish of why this keeps happening, because if you look at the history, it's like this big, and it's usually from 1 or 2 people only. And it's my backyard, my personal space. And I was trying to just show a timeline that my backyard's been the same ever since I've owned it. It's only when my neighbor.
Right now, we're just trying to decide if this evidence gets to come in. Then you
Okay.
get to do the rest of your discussion.
So honestly, I'm not sure of the relevance, but I won't object to this one.
Okay. And what was the second one? Okay. All this is a timeline to show you the time and the date of the debris that's been there, and there's never been an argument or a call ever put in.
This picture is showing, I guess, his backyard. The issue I would have is I really don't have an objection to you seeing his backyard. The point that I would like to make is that At the day and time I do an inspection is all I can determine. I don't know what happened in the past. I don't know what happens in the future. All I can determine is the day and time that I am there when I receive the complaint. So I have no objection.
Let's go ahead and start marking these. So the first photograph, I would suggest that you mark as Respondents Exhibit A. The second one would be Respondents Exhibit B, and so on, so that when they're being referred to, we have a good record. So there's no objection so far, Madam Chair, for Respondents A and Respondents B, so those should be received into evidence. And then as to the other two photographs, we'll deal with those next.
Okay. Bobby, you also mark those?
And all this one is to show another timeline, that every time I move something, he comes out of his house, takes a picture, and calls code enforcement, and of, yes, it's a violation. But you gotta look at the time frame. He deliberately waits there because he has 6 cameras pointed on my property. As soon as I move something, calls code enforcement, takes a picture. But you can see him right there taking the pictures.
So again, I really don't think it's relevant. However, I won't object. I'll let his evidence go in. Again, I do want to make the point, however, that my job, code enforcement, is there's a violation at the time I'm there, or there isn't. If it comes into compliance by the deadline, it doesn't come to code board.
So we'll mark that as Respondents Exhibit C, please.
And
One
Bobby
last
will
one.
accept that
Yep.
as
What I mean.
evidence.
Just this one, Beth. This one you can clearly show, he's in my yard measuring the shed, and then there you are, code enforcement, responding. And this is what happens all the time. My shed's been there since 1959, and I got written up for no permit. I wasn't even born then.
So there is a picture of me and Mr. Antoniades' property. The picture below it, whether his neighbor trespassed on his property or not, it's definitely not at the same timestamp time when I was there. So that would be an
We don't
issue
have
that
any
has
trespassing
nothing.
issues facing us, so we're
The issue wasn't trespassing.
irrelevant.
So there's a picture of me on the property and Sergeant Miller, on the neighboring property, 747 Sunset Drive. And then there's a picture of someone else, which I thought you had said was trespassing on your property.
I did say that, but I know it's irrelevant to that. I was just showing that it's a continuous problem with the neighbor, that no matter what I do in my yard, he gets a call into code enforcement and it gets written up.
So again, I won't object and just make the point again that when I'm there at the time, there's either a violation or there isn't.
I think he wants us to put it in the record. We're willing to do that. Thank you.
So
Bobby
the-
will mark it.
Yeah, be Respondents Exhibit D.
And then just this last one, Beth.
All right. Now we have your evidence,
I think you wanted one more.
but we're not even addressing that today, so
It's in
you can
regards-
present it to
okay.
her, but it's kind of no point on that one.
And that's why I asked for a continuance. I have all the stuff that's in compliance on pictures. I did not have time to print everything out. I just got in at 2 this morning.
And you realize that you have to call code board and they have to come out and do it. Your photos of compliance don't meet the standard.
No, but I was bringing them in for the board today.
Okay. Go ahead, make your case.
That was my case.
Do you have any questions for him?
I guess my main question would be, is there any reason you don't want to allow me, or didn't want to establish a day and time for me to come verify the violations are in compliance?
I mean, can I answer that if it's not relevant to what's going on right now?
It is 100% relevant.
Okay.
That's why we're here.
All righty. Well, there have been several occasions that Beth has come out to the property and written me up for stuff that was non-existent. Even though you don't want to hear it, she just
I-
asked why,
Irrelevant.
but she asked why I didn't want her on the
Well,
property.
he's answering the question.
If you want to be in compliance, according to the city codes, you have to call them. They have to
did.
come and look
I
and
did.
say, yes, it's in compliance.
I absolutely 100% did, and Ed Miller refused to come out.
She asked him why he wouldn't allow her to go in and take the pictures. I think, is he gonna answer that?
Well, to come do a final inspection, yes, I
Yeah.
did ask.
And I did call Ed Miller and asked him to come out, and he refused to come out. When you have a problem with somebody in the chain of command, you go to their boss, which was recommended by Beth. She says, if you have a problem with me, contact my boss. I contacted him for reinspection, he refused to come out. What am I supposed to do after that?
We don't know why he refused.
It's in his email, which unfortunately I didn't get to print out, but it's very well documented.
Okay, so do it,
The board have any questions for the
Oh,
owner?
I think Beth was still talking. You were
so
talking.
I'm sorry, yeah, I'm just deciding whether I have any other questions. So I guess, are you going to allow me to come out to do a final inspection?
If you come with somebody else, yes.
Okay. So we can set up a day and time when,
You could come right after we leave this meeting.
we'll set up an point. Okay. So you believe you're in compliance at this time
Oh, absolutely I am.
with all the violations? Okay. I just wanted to ask that for when it comes to how much time you need to come into compliance. So you believe you're completely in
Right.
compliance?
One other issue I just wanted to clarify, you had written up for the pavers in my backyard. Where am I supposed to put them?
Unfortunately, I can't tell you what you have to do with it, but the definition of debris, unused materials being stored externally is considered a item of debris.
Pavers that I'm gonna be using for my walkway?
You could store them in your shed, I'm assuming.
I had a question.
Thank you.
Yes.
Is the shed been removed or repaired?
It's been repaired, but originally, if you look, the original complaint was it cannot be repaired, it must be torn down. It was only 2 days ago I received an email from Beth, which I got yesterday, that says I can repair it. So if a violation is a violation, make up your mind what you want. You either want it torn down or you want it fixed. And I was only received that notice 2 days ago, which she could verify with her email.
So
But the
the-
original complaint was, it has to be torn down, no exceptions.
That's not what
If
well, I'll
you read the
respond
email,
when.
So at the current time, the shed is still there, so that to be in compliance, we either need to bring the shed into compliance or tear it down. And have you made, application to do one or the other of those with the city? You can do that right on, it's been since February.
Right, I do not need an application. She clearly stated in her email that an owner could fix and repair their own shed without any permit.
Okay.
But I only received that 2 days ago.
But you feel like the shed is also in compliance at this time?
Absolutely.
Okay. So you feel like that if we give you how much time, you can get this scheduled and get all this in compliance?
Get into compliance if I just testified it's in compliance.
To us, it's not until the
Okay.
city has
I
inspected.
guess we wouldn't know until she inspected it. Because if she has a difference of opinion on the law, then I'll have to correct whatever she says, right?
I think Beth wanted to say something.
Pardon?
Do you have any closing statement?
Just that, that the violation was not from me, from code enforcement, was told to repair, remove, or replace the shed per the building department's instructions. So that was what the violation was, and then determining what the building department required for the repair. I personally did a bunch of research and did speak with the building official and the planning and zoning official because it is an old shed. It's been there since 1959. And we did get some clarification. He's correct. I sent an email which was probably very helpful to him in order to try and get the repairs. But again, it's always been per what the building department official deems is appropriate because he is the expert in that area with the city. So he did give clarification. And as long as he's done what the building official asked, then it would be in compliance, but we do just need to verify that.
So you just need to reschedule a final inspection.
Yes, although, just to be reasonable, I would agree that just in case what he deems is in compliance and I deems differently, I would suggest that we give, a little bit of time so that he has a chance to do that without getting a fine.
Do you have any other summary that you need to make, Mr. Durso?
No, thank you.
The public portion of the case is now closed, and I'm ready to entertain a motion.
I move that based on the testimony, evidence, and facts presented by law at the time of the alleged violations, sections 8-52, 8-40, and 42.00 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Do I hear a second?
Second.
Thank you. Roll call, please.
Mr. Stammes?
No.
Mr. Perfidio?
Aye.
Ms. Teliar?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes.
The motion carries.
Having been found not in compliance, the penalty phase should be addressed. Would anyone like to make a motion on that?
I move that the respondent shall have until the June the 30th to bring the property into compliance with Code Sections 8-52, 8-40, 42.00, or suffer a fine of $50 per day each day thereafter that the respondent remains in violation thereof.
Do I hear a second?
Second.
Thank you.
Questions?
I heard two, I don't know.
Mr. Perfidio? Thank you.
I have a question.
Okay.
Can you get that in compliance by then, or do you need more time?
He says it's in compliance now.
But I don't know because I'm not code enforcement. It's in compliance to what I think is correct. So you know what I mean?
Okay.
Roll
This
call,
is
So-
please.
then.
It would determine when code enforcement gets out there, whatever their decision is, and then how much time they're gonna allow me if it doesn't meet their criteria. So that'd be a question I couldn't answer for you without them actually seeing it. Because I have, which nobody wants to
Go out
hear,
there.
an original from before.
Okay.
Roll call, please.
Mr. Stammes?
What are we, I forget what, I.
He's been given until June 30th
30th, okay.
to make sure that the inspection is complete and he's in compliance, or the fine is $50 a day.
Okay, but I voted no on the, yeah, so no.
It has been, the motion has been made and seconded, so now we're ready for the roll call.
Yeah.
And Mr. Stammes?
No.
Very good. Mr. Perfidio?
Aye.
Mrs. Teliar?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes,
Motion
motion
carries.
carries. We'll summarize this for you, and then they're going to mail you something additionally.
So, sir, you've been found in violation of the three code sections that were cited, 8-52, 8-40, and 42.00. You've been given until June 30th to bring the property into compliance. Should you fail to bring the property into compliance by that date, a $50 a day fine will be assessed. If you don't know what you need to do to bring the property into compliance, you can contact code enforcement after the meeting. As from what I've heard tonight, there obviously is going to be an inspection fairly quickly, and then you'll be able to ask those questions at the inspection as to what would be required to bring it into compliance. The board is going to enter an order. That order will be in writing, and it will be sent to you within about the next 10 days. If you have any questions, please contact code enforcement after the meeting.
Thank you for coming. Case number 2 was deferred. Case number 3, 17-800000748, 119 East Lime Street, Alternative Capital Qualified Opportunity Zone Fund. And Bush Ross is the registered agent. Is anyone here for that property? Then the city can present its case.
Sorry, I was having to pull something up real quick. Okay. So this is case number 17-800000748 for 119 East Lime Street. The property owner is Alternative Capital Qualified Zone Fund LLC, registered agent Bush Ross, registered agent services LLC. Exhibit 1 are all the photographs. Exhibit 2 are all the notices, to include the notice of violation and notice of hearing. Exhibit 3 are the administrative documents, to include the case summary, property appraiser, and tax collector records. Exhibit 4 is the affidavit of posting and a copy of the sign. All of the photographs and exhibits that were given to the violator are exact copies of what is being presented to the board. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violation and notice of hearings are sent return receipt when requested in first-class mail. Madam Chair, please accept all exhibits into the record as evidence.
Thank you, Bobby will do so.
Yes, ma'am.
Okay. So on March 24th, I conducted the initial inspection. The reason I went back out there was Officer Boone had asked me to meet him at the property due to his concerns with a lot of criminal activity occurring on that property as well as in the area. And it has continued to deteriorate over many years. This building was actually condemned a long time ago by the building official and has gone through a foreclosure process. So the reason you see that 17 is the case is I just try to keep all the history of the case in one, the progression since it started in one history. So the property was sold and is now it was foreclosed upon and then sold under this Alternative Capital Qualified Zone Fund LLC. So basically the property was still in very dilapidated condition. I'm going to show you pictures. It's still considered unsafe and uninhabitable, and the property was overgrown and had lots of trash. So when we discovered that there was, again, a new owner, on March 24th of 2021, the notice of violation was mailed and the green card was returned, signed COVID-19. On April 30th, after we had already extended, the contractor for the property owner had requested an extension that we did grant from April 9th to April 30th. And we had been told that we would be emailed pictures once the initial work was completed, which we never did receive. So therefore, I did the reinspection on April 30th. The property still had trash and debris. The fence was in disrepair, overgrown in many places. The building had not been repaired. No permits had been pulled, and we had not heard from Tracy, who was the person that had emailed us stating she would update us on the status of the property. So on May 19th, the notice of hearing was mailed. The green card was returned signed, COVID-19, and the postal tracking system showed that the registered agent was delivered the notice as well. On May 28th of 2021, the sign was posted and affidavit of posting was signed. On June 9th of 2021, a final inspection was conducted. The yard had been cut and a lot of the trash had been removed, at least on the Lime Street side. There's an alley behind the property is the reason I put it that way. The house is still in disrepair, still boarded up, and still no permits have been pulled for the repair. So, let me pull up the pictures. Okay, So, sorry, I was used to Zoom sharing pictures, now I'm having to do it a different way. Okay, so this is part of the structure. You can see that it's boarded. It's being overgrown by plants and such. This is just another picture. This is along the alley side that goes behind the property. There's quite a few buildings on this property, actually. So again, it was overgrown, trash and debris. It's been in this state for years. This is just, I believe the city had actually abated this property at one point by putting a fence around it. That's why the fence is somewhat newish looking. However, parts of it have been pulled down, damaged, and destroyed. I don't know if you can see up here, there's the roof, it basically has a hole in it. It's falling in on itself.
Thank you.
Again, just property of the overgrowth and the boarded windows. This trash has been cleaned up. Just overgrowth and more windows. There's more just showing the overgrowth and the buildings in disrepair. You can see that at one point there'd been a tarp over the roof. And that's it. Those were just the pictures taken in, the most recent pictures taken in March. So basically, what I'm requesting is that the board find the property in violation of City Code 8-52 nuisance prohibitions, 8-40 duty to maintain private property, 36.03 for fences, walls, and hedges, Florida Building Code 105.1 for permits required, City Code 6-1, which adopts the Florida Building Code, and 8-22 for the accumulation of trash. And that concludes my testimony.
I have a question. Why is this not a repeat violator?
Because the property owner has changed. So basically, the property has had multiple code cases. It ended up going through bank foreclosure. Then I believe it was sold, had a new owner, and then even since the sale of last year, there's now another new owner. Therefore, we've had to start the case yet again.
Does anybody else have a question for her?
What kind of violations? Are the same violations then as they are now? Because I remember this case a long time ago, and we asked the owner to go ahead and put up a fence around it, and we were happy with that, as I remember it, just as I remember it. Don't forget, I'm pretty old, so.
Right. It's my understanding that nothing other than the just very recently that they had cut the grass and have removed some of the trash is the only thing that's been remediated probably since the last time you saw it.
But the plan is to develop the property. to work on
Honestly, I don't know what their plan is. They just either need to demolish it or to repair it with permits is my position.
it. And you said there were other buildings on the property?
Because I can't trespass, I haven't been on it, but it appears to me there's more than one building on there.
Yeah. And you were alerted because of criminal activity on the property?
Well, we had known that the property had changed hands. We had sent them a notice. And then when Officer Boone asked me to come take a look at it again, I realized that the property he'd asked me to look at was this property with this code case, and realized there was then again another new owner. So that's when I again sent the notice of violation.
Would anybody like to make a motion?
Yep. I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violations, sections City Code 8-52, 8-40, 36.03, FBC 105.1, City Code 6-1, and City Code 8-22 were in force and effect, and the respondent was in violation thereof.
Second.
you've seconded?
I think
Okay.
Mr. Stamos did, actually.
Mr. Stamos did, yeah.
The motion's been made and seconded. Roll call, please.
Mr. Stamus?
Yes.
Mr. Fudio?
Aye.
Mrs. Telliar?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes.
Motion carries.
First motion has been passed. Does anybody like to make a second motion?
Are there fines on this property pending?
There are previous liens, but not for
Not
this property owner.
Okay.
Not for this owner.
Not for this owner, but previously.
And the amount of the previous,
I'm sorry, I don't have that. And Mr. Trask, may I ask you, with the fact,
They've been wiped out in foreclosure.
because of the foreclosure, that's what I
Right.
thought.
Okay,
So there's no pending fines on this property because the prior fines were wiped out.
okay.
Okay.
And we think a month or more?
So, this is the problem. I haven't had communication with, in fact, Brian, if you could, did she say whether, when she had communication with you, whether she was going to demolish or repair with permits?
Not advise either.
That's the problem. If they know that we were having this hearing today, and I was hoping they would actually be here. It's hard for me to answer that because if they were to do the repairs, it's obviously going to take longer to pull the permits and do the repairs. If they were to demolish it, it really shouldn't take that long. You'd pull the demo permit and just have that done. So it's hard for me to fairly answer that question.
This is a problem that's,
I would definitely like to give them a reason to bring this into compliance quickly. It's been going on for a long time, and as I said, the criminal prevention officer is the reason that pulled me out there to take a look at it again, which fortunately he did because, again, the ownership had changed again.
okay, I'll make a motion.
okay.
I move that the respondent shall have until July, I'll give him 1 month, July 9th, to bring the property into compliance of the said motions, violations rather. Violation of 8-52, 8-40, 36.03, 105.1 of the Florida Building Code, City Code 6-1, and City Code 8-22, or suffer a fine of $50 per day thereafter. Or the respondent will remain in violation.
Second.
Bobby, roll call?
Mr. Stamus?
Yes.
Mr. Fudio?
Aye.
Ms. Telliar?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
I'm going to say no because I would have made it
More,
300,
yeah.
but
I almost,
motion carries.
yeah.
Yeah. We have 2 cases with the same person, but we're going to address them separately. Item number 4 is a repeat violator, 21-8, 0000284, 1673 Seabreeze Drive, Peter Tumalo.
Madam Chair, can I address the board first?
And Mr. Tumalo's not here today.
But, Madam Chair,
Mr. Perfidio has.
Yes, sir.
can I address the board first?
Yes,
Okay,
please.
Thank you. Okay, I just wanted to inform the board that this morning I ran into Mr. Gary Upchurch, who is the property manager for Mr. Tomilo's property, at which time, I told him point blank that I will not discuss ex parte code board.
Like
How you
before.
doing?
He's got to
Were
be
these
sworn in.
people sworn in?
Do I have
And
to sign
then
this
you
here?
came later to the meeting, so before we start, we'll ask both of you to stand and raise your right hand, please.
Do you swear your testimony you're about to give us the whole truth, nothing but the truth?
Yes.
All right, thank you. Be seated.
All right, Beth, go ahead.
Brian, did they get a chance to see the exhibits?
Yes, they have copies.
Okay. And I don't know if they have any objection to the exhibits or not.
Ask if they have any objections.
Do you have any objection to the exhibits being presented?
No.
Bobby will sign those in.
Okay. So my name is Beth. I'm the certified FACE code inspector for the city of Tarpon Springs. This is case number 21-800-00284 for 1673 Seabreeze Drive for Mr. Peter Tamillo. Exhibit 1 are all the photographs. Exhibit 2 are all the notices, to include the notice of violation and notice of hearing. The Exhibit 3 are the administration documents, to include the case summary, previous board orders, property appraiser, and tax collector records. Exhibit 4 is the affidavit of posting and the copy of the sign. Exhibit 5 is the affidavit of prosecution costs. All of the photographs and exhibits that were given to the violator are exact copies of what is being presented to the board. All notices were mailed to the property owner of record as determined by the Pinellas County property appraiser and tax collector databases. All notice of violation and notice of hearings are sent return receipt requested in first-class mail. And please accept all the exhibits into the record as evidence.
Thank you, Bobby.
Yes, ma'am.
Okay. So we have had contact with the owner, Mr. Tamillo, by email. On May 6, 2021, I conducted an initial inspection. Mr. Rich Snyder was outside the property when I drove by. I stopped and asked him if I could ask him a few questions. He stated he and his wife, Marianne Snyder, were staying at the house Monday through Sunday, which was May 3rd to May 8th. And Trish's name was on the lease. He gave me his phone number also. On May 7th, sorry, I'm fixing something. Okay. On May 7th, the repeat violation notice of hearing was mailed. The mail was returned unclaimed, and an email was sent to the property owner as well. On May 11th, we conducted a reinspection. When I arrived, it appeared there was a different car in the driveway, and from when I spoke with Mr. Schneider, it was a different tag of a Florida tag of LCXX52, and when I ran the tag, it was a lease vehicle. I knocked on the door with no answer, so I left a door hanger asking for the occupant to call our office. On May 12th, we received an additional complaint. On May 13th, we received another additional complaint. And on May 17th, an amended repeat violation notice was mailed. The only reason that notice was mailed, Brian, can you confirm this was to let them know that we weren't doing hearings by Zoom anymore? Okay. So that was the only reason the amended notice was mailed. And on May 18th, I conducted another reinspection. The complainant stated there were people present that morning. When I arrived at 4:30, no one was present at that time. So basically, I couldn't verify that anyone was at the property. The last screenshot that I'd had for this particular case showing that they were still advertising for short-term rental was of May 11th. So what I'm asking is for the code board members to find the, and let me finish the history, I apologize, I'm getting ahead of myself. So on May 20th, an email was sent to the property owner letting them know that we were going to put the property in compliance as of May 12th. And on May 28th, the sign was posted and the affidavit of posting was signed. So basically, to go back to what I was trying to explain, that the dates we're looking for this property to be in violation would be from the date Mr. Snyder said that he was there, which was on May 3rd, until the last screenshot that we had showing that the advertisement was still listed as being advertised short-term, which was May 11th. So they would actually be in compliance as May 12th. So long story short, we're looking to have the property found to be in violation from the date Mr. Snyder said he was there on May 3rd until compliance as of May 12th.
Total number of days not in compliance, 3rd, 4th, 5th, 6th, 7th, 8th, 9th, 10th, 11th, counting the 12th or not?
They were in compliance on the 12th, so that would not be a day of violation.
So 9 days.
9 days.
Yes, ma'am. So, let me go ahead and bring up the pictures. Okay, so this basically is just showing the advertisement for the 6-night minimum for Airbnb. Again, the same thing, minimum 6 nights. Another minimum of 6 nights. 6-night minimum. Pretty much the same thing, just showing the different minimum days, or the 6-night minimum. This was just the door hanger that I left when I was asking the occupant to give me a call back. This was just a picture of the car that was the lease vehicle. So the other thing I wanted to make note of is this case is a repeat violation case. This would be the 5th repeat violation case for this property if it is found in violation. The previous repeat violation cases were 21-800-00197 in violation of 25.02. His previous fine for that case was $100 a day, totaling $1,124.50 approximately. It has not been paid yet. The other repeat violation case was 21-800-00154, same violation of 25.02. He had received a fine of $100 a day, totaling $395, and has not been paid. Then the other repeat violation case was 20-800-00735 in violation of 25.02. Those fines were $25 a day, totaling $550. He's paid $140 of those fines. The other repeat violation case was 20-800-00229 in violation of 25.02. It was complied prior to the deadline and had been assigned $50 a day. So basically, he's had 4 previous cases. This would be the 5th. And it's gone between from $25 to $50 to $100 a day. And this has all been since 2020 that we've had these, now this being the 5th case. So to summarize, I would like the code board members to find this property in violation of City Code 25.02, single family resident district, from the time of May 3rd to May 12th of 2021. And that concludes my testimony.
Do you have, you just get to ask her a question, and then you get to make your case. Please identify yourself.
Gary Upchurch. No, I don't have any questions. I just have a few things I want to say.
Gary Usher?
Upchurch.
Upchurch, thank you.
Like that place your mom makes you go on Sunday. So, first of all, to Rich's statement, I am not a property manager of this property. I know that you guys think I am, but I'm not. I make no decisions. I have no control over anything. I pick up the trash. I make sure there's water in the pool. I fix broken faucets. And that's about it. I let contractors in and out and other people. And yes, Rich is one of our neighbors. And we all had coffee this morning down at Panera Bread. And we talked about things like big government overreach and stuff like that. But we didn't talk about this property. He made it very clear that that would be unethical of him, and he did not. And I want to say that I really feel like you guys are doing a disservice to the city, the people of this city. There's-
This isn't the time.
I'd
for
like to
that.
say what I came to say, please.
This is just to
If that's
present
okay,
evidence.
I'll be brief, and then I'll be gone. Because you guys are going to do what you're going to do, and it's not going. Whatever I say is not going to make a difference. But I just want to go on the record as saying, you guys are really doing a disservice to the city, the people of this town. People like Pete Tamillo, he's a great neighbor. He's improved his property. He brings people to this town that spend money down there on the sponge docks. And by the way, those aren't local people down there spending money in those shops. Those are people that
I'm
the
sorry,
other
sir.
100
This is just totally
properties
irrelevant.
on vacation rental by owner, and there's 100 of them.
I'm going to have to
are
declare
bringing
you
to
out of
this
order.
city. And you guys have picked Mr. Tamillo to harass. I don't see any of the rest of the vacation rental property owners here today. And there's 100 of them just on vacationrentalbyowner.com.
Completely irrelevant.
No, it is relevant. You guys don't have
Mr.
to do this.
Upchurch, just hang on just a second, okay? This is not appropriate. The chair has objected
It's
to it.
appropriate. I think it's
You need to
appropriate, and I
stop.
said what I had to say. Now you do whatever the hell you
Otherwise, you're going to be removed.
You don't have to remove me. I'll leave.
All right, so do you have any evidence that you want to present on behalf of the property owner?
No, I just said what I had to say. Do whatever
Thank
the hell
you.
you want.
Okay.
And you can appeal to this board of the city to have your property rezoned if you wish to have that kind of property. Go ahead. We have someone else for this property?
You guys have anything you want to say, Frank?
I'll say something here.
Sir, if you can identify yourself, please,
What's
your name?
name, please?
I'm sorry, ma'am.
What's your name, please?
Frank Perry.
Frank Perry, thank you.
I'm a neighbor. I know Mr. Tamillo, much like Gary said, Pete improved the property. It was basically a tear down. I'm surprised he saved it. He did a great job on it. I understand that the law is the law. We can't change the law here. We're going to be under state guidance. Is that correct? As far as code enforcement, this is what I was told. If we would make changes to our code in Tarpon Springs, then we'd fall under the state guidelines for temporary rentals, and you could even rent for one night to people. Is that true?
This isn't
I understand. I was just trying to clarify that.
not the place to do that, I'm afraid.
Yeah, the issue here with Mr. Tamillo, though, if he hasn't told you this already, is he felt it was selective enforcement because he was the only one.
He's told us that on numerous times.
I didn't know
But he's
that.
also under oath lied to us, and that's a problem.
I didn't know that either, ma'am. So he asked me to come down here. I thought he'd be here today, and that's why I came. So as far as, I don't have a whole lot to give you as far as evidence. I don't inspect the property. I walk by there twice a day. That's it.
Thank you very
Sorry.
much.
Okay,
Thank you.
thank you.
I don't believe anybody has any other testimony. Do you feel like you've summarized appropriately, correctly?
I guess the only thing to summarize is that this is a continuing issue with this property, and honestly, I just feel like either he's
He's going to comply or he's not, and
or he's I have never recommended this, and I don't enjoy doing it, but I think the only way for this to not continue is if it's the maximum $500 a day.
I understand. Thank you. Appreciate your input. Would anybody like to make a motion?
One sec, Beth, you can do nothing more, and I want this to be stated, you can do nothing more but to enforce what's in front of you based on the code. And that if they have an issue, they need to go to the city or wherever this can be changed in terms of zoning. Is that not correct?
That's correct. Neither I nor the board can change the
Anything other than
Muni
that.
code. Yes, ma'am.
Exactly.
What is the minimum?
Excuse me?
What is the minimum to,
42 days?
42 days, I believe.
Oh, for time frame?
Yes.
people
Yes,
are
ma'am.
rent-
It's a minimum of, it goes by the definition of tourist home. So under this zoning, they, if they can rent, as long as it's more than 6 weeks, so 43 days.
You don't have anybody that comes in and just rents something for 2 weeks?
You can, but then you can't rent it again until 43 days after that.
So you should have a lease that you're renting for 6 weeks. And Mr. Trask, feel free to stop me if I'm saying this incorrectly, but from what I understand is, you know, things happen, people might have to leave before then, but yes, it would be a violation if you then rent to another person within that time frame, because it's a 6-week minimum.
You would write them a lease for X amount of time, but then you can't write another one for 42 days.
I just wondered why it's so
Doesn't matter if they stay
long.
there 2 days, but you just.
Who makes this, where does this come from? Does this come from the?
It's a zoning code. 25.02 is the single-family resident zoning. So basically how it determines whether it's allowed or not allowed is every single zone has permitted uses and conditional uses. This zone does not allow tourist home as a permitted use, which is allowed outright, nor as a conditional use where you can get approval through the city. So because it's not allowed, you just cannot do it, period. And the definition of a tourist home is basically anything, if someone's staying there, if someone is renting the property for anything less than 6 weeks. So the property is not zoned to be a tourist location, so basically what's happening is it's being used as a tourist location. So it's being used for a way that is not allowed in that zone of 25.02.
When you say zones, are there several zones in the city, or?
There are many zones in the city, yes, ma'am.
So in other areas, they would be. they could
Right,
rent
so there's
for-
other areas where it's absolutely permitted. There's some areas where it's permitted outright. There's some areas where it's permitted if you apply for a conditional use permit. The Board of Commissioners just approved one this week. But that property it's allowed in that zone for that location. But this location where he is zoned is only a single-family residence. It's not allowed to be used as a tourist home.
And when they open up to decide to do this, the owners, do they know ahead of time how, you know, how long they have to rent it for?
He's been
Are they
given the
told?
rules.
Well, when you purchase a property, it's pretty much up to the owner, I believe. I don't think the city is responsible to tell an owner what they're allowed to do when you purchase a property. I would assume that's upon the owner to understand what they can and cannot do with the property. But at this point, this is the 5th case,
No, I understand that.
so
I'm
I
trying
think
to-
he's well aware.
Oh, yeah. I'm just trying to learn a little bit more about it, so,
Right. Did I answer all your questions?
yes.
Does, where it makes sense?
Particular area is zoned
If
differently.
you buy a house here, you better look at what zone it is if you're planning on
Absolutely.
renting it out.
The area is highly residential, and if you can see some of the areas downtown that are, quote, tourist, and they have B&Bs and things like this, but this is a highly residential area.
Yeah, I know. I live right close to it.
There was a similar, I know this is off the thing, but there was a similar case where 2 residents, at the end of Enclo, there's an island community at the end of the sponge docks. And they were listed, but nobody knew it, as a rentable community. But the whole group of homeowners said, this is not what we want. And they had the zoning changed so that it could not be rented under any circumstances. And the 2 people who had purchased for that reason got outvoted. So even though they bought a home as a rental, they can't rent them. Except for every 42 days they could, or 43. You just have to know what you're buying and know the codes where you're buying. Okay, we didn't finish the case, so sorry, Mr. Trask will be after me. Let's move it along, ladies and gentlemen.
Well, it's, I
Motion
think you need me
for,
to know, too.
All right.
where are we, Bobby? Did we do the,
We need a motion.
did we
Need a
do the
motion.
guilt phase?
It's only one motion, it's a repeat violation.
Repeat,
Oh,
okay,
that's
sorry,
right.
sorry,
I'll go
sorry.
ahead.
Turn the page.
I move that based on the testimony, evidence, and fact presented by law, that the respondent was in violation of Section 25-2.
25.2.
O2.
25-02 of the city code from May the 3rd until such time as the property is brought in, from May the 3rd.
May 3rd to May
To,
11th.
sorry, a fine of $500 a day per day shall be imposed until compliance is met. In addition, the city is awarded $127 for the cost it incurred in prosecuting the case.
I thought he was complied already.
For those
Is he in
9
compliance?
days.
9 days. Yeah.
Yes, I'm sorry. He was,
He's
in my opinion, in violation from May 3rd and was in compliance on 5/12.
Right, so 9 days,
So 9 days,
$500 times 9.
Mr.
$40,000.
Mr. Weeks, do you want to include that in your motion then?
Yes.
Violation from May 3rd until May 12th
May the
instead
12th.
of compliance?
9 days?
Okay.
Yes, thank you.
Is there a second?
Second.
Thank you. Bobby, roll call?
Mr. Stammes?
Yes.
Mr. Perfidio?
Aye.
Mrs. Telliar?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer? Ms. Wade?
Yes.
Motion carries.
We're going to have the same issue again on item number 5. Case number 21-8000305,
Same residence.
1673 Sea Breeze Drive, Peter Tumillo. There's no one here for that case. City could proceed, please.
Okay. So my name is Beth Hughes. I'm the FACE Certified Code Inspector for the City of Tarpon Springs. This is case number 21-8000305 for 1673 Seabreeze Drive for Mr. Peter Tumillo. Exhibit 1 are all the photographs. Exhibit 2 are all the notices, to include the notice of violation and notice of hearings. Exhibit 3 are the administrative documents, to include the case summary, previous board orders, property appraiser, and tax collector records. Exhibit 4 is the affidavit of posting and a copy of the sign. Exhibit 5 is the affidavit of prosecution costs. All of the photographs and exhibits that were given to the violator are exact copies of what is being presented to the board. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violation and notice of hearings are sent return receipt requested in first-class mail. Please accept all exhibits into the record as evidence.
Bobby, you'll do so, please.
Yes, ma'am.
So again, this is a repeat violation he was in violation, repeat violator for case 21-800-00197, 21-800-00154, 21-800-00154, 20-800-00735, 20-800-00229, and this last case is now a repeat violation for 21-800-00284. We have had contact with the owner by email. On May 19th, I did an initial inspection. When I arrived, there were 3 cars in the driveway. I knocked on the door and spoke with a Jana Purley. She stated she was staying there through VRBO website from May 17th to May 23rd. She lived in Ohio, and there were several adults and several children present. She stated she had spoken with the property owner when she had made the reservation. On May 20th of 2021, the repeat violation notice of hearing was mailed. Postal tracking states that the notice was left and no authorized recipient. We also sent an email to the property owner. On May 23rd, we received additional complaint. And on May 24th, I did conduct another inspection. Verified there was a new vehicle in the driveway, license plate number JKKP26. It was a short-term lease vehicle owned by Six Rent-A-Car LLC. I rang the doorbell with no answer and left a green card on the windshield requesting a call to our office. The short-term rental advertisement was still short-term on 3 websites that we checked. On May 28th, the sign was posted, an affidavit of posting was signed. On June 2nd, we received an additional complaint that a new tenant was present. On June 7th, we had received another additional complaint that another new person was present. On June 7th, I did do a physical reinspection. There was a trash can in the right-of-way, an inflatable ring in the backyard, and a children's bucket of beach toys in the front that I had not previously seen. No one did answer the door when I knocked, and I did try to do it again, do another visit again. So on June 9th, 2021, I did conduct another reinspection. The bucket of toys was gone. There was no car in the driveway. The trash can was still out front. I did attempt to knock on the door to see if anyone would answer, and nobody did answer. However, even though I'm not sure if anyone is there now or not, it is still being advertised on the website that he, or the company he has testified as using, Evolve. It's still showing that you can make a short-term rental. He is aware that this is going to the board, is being presented, and that we do consider it in violation. Airbnb still shows it as a minimum of 6 nights, and I'll go ahead and pull up the exhibits right now. And I don't believe, we have not been told it's, Mr. Tamillo has not stated it's in compliance, right, Brian? Yeah, we've not been instructed that it's in compliance. Okay, so this is just one of the pictures, just showing one of the vehicles from Ohio that was in the driveway. So, like I said, this was a party with 3 vehicles, so there were quite a few people there when I went. This actually is the short-term rental agreement on the Evolve website that says that, let me read what it says, because I can't see it from there. It is expressly understood and agreed that this is a short-term and transient vacation rental. That's on the Evolve website, which Mr. Tamillo has testified to using multiple times. So this is just showing that they were able to do a short-term booking. Again, another minimum of 6 nights. Minimum of 6 nights. Evolve minimum of 6 nights. That's basically what these are showing. Like I said, the last time I went out to do an inspection, trash cans hadn't been out previously, so I kind of am making the assumption, or it leads me to believe that someone put the trash out. And there, like I said, there were a bucket of children's toys and a pool inner tube there that I had not seen previously. Again, the short-term rental was still. So with this property, we basically have gotten to the point where we're just checking daily. So the entire time that that this case was opened, we have checked daily, and that it has there has been a short-term advertisement the entire time. So I basically am asking the code board members to find this property in violation of 25.02. And I believe that the property was in violation from the date the tenant told me they arrived on May 17th, and is still in violation today. I did verify today that the short-term rental advertisement has not been changed. And that concludes my testimony.
The 10th?
So continuously from May 17th until June,
It's my opinion, because the short-term rental advertisement has not been changed. It is still, in my opinion, is still in violation.
did you count how many days that was? We can do it.
No, because it's not in compliance, so it's still not in,
4, 5, 6, 7, 8, 9.
because it'll continue to be in violation until it comes into compliance.
Right. Non-compliance. Okay.
Anything else? Anybody have questions for her?
Yeah, I have a question. When you were going through the Evolve website, did you check to see if Evolve was made aware of the city code concerning a minimum stay?
No, because in my opinion, it's up to the property owner. He's the one that cited. It's up to him to be in compliance.
But did you see anything on the website that said that they should be being made notified of something like that?
No, I didn't, and I didn't look for it, though, to be honest with you.
Okay. Have you either, let's see here. That's it. If they were not I wanted to know if they were notified of a minimum stay, but if you don't know, it might be interesting to check out to see if their contract requires that.
Gotcha. Thank you.
I couldn't hear him either.
Couldn't quite understand you.
I just wanted to know if she saw in the contract that she put up there, if she saw anywhere where Evolve mandates that they must be notified if there's a minimum stay requirement in the city that you're listing your property in.
That who must be notified?
Evolve, the company that lists these websites. It might be interesting to know that.
Irrelevant, I think.
It's not irrelevant at all. It's very relevant. If Mr. Tamil has not notified them if there's a minimum stay in the city of Tarpon Springs, then they wouldn't list the property in the first place. It'd just be interesting to know, that's all.
He had said that that they're making the mistake, that the
No,
Evolve or
no,
whoever
no.
is,
So Mr.
he was here
no.
Mr.
before.
Tamillo's culpable before not informing them.
Yeah, that's what
So
I
he's
asked a
in the
very
wrong.
simple question.
Stop.
I asked a very simple question.
Within the time frame.
If she saw that anywhere in the contract, it might be interesting to know. That's all I'm saying. Thank you. I didn't say anything else.
Would anybody like to make a motion, please?
I move based on the testimony, evidence, and facts presented in the law that the respondent was in violation of City Code 25.02, City of Tarpon Springs City Code, from the date of the initial inspection, which you're going to say is the 17th.
That was the date that the tenant said they arrived. Yes, ma'am.
Such time, and until such time as the property is brought into compliance, and a fine of $500 per day shall be imposed until compliance is met. In addition, I move that the city be awarded $94.50 for the cost of incurring prosecution in this case.
Second.
Roll call, please.
Mr. Stammes?
Yes.
Yo?
Aye.
Mrs. Telliar?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes.
Motion carries.
Item number 6, repeat violator 21-800000294, 1116 Gulf Oaks Drive. The name of the person is London Eves. Is there anyone here for that property? Being none, the city will present its case.
Okay, my name is Beth Hughes. I'm the FACE Certified Code Inspector for the City of Tarpon Springs. This is case number 21-800000294 for 1116 Gulf Oaks Drive. Property owner is London Eves. This is a repeat violation case. The repeat violation case number was 21-800000189. And there was no previous fine. It was simply established at that time. Exhibit 1 are all the photographs. Exhibit 2 are all the notices, to include the notice of violation and notice of hearings. Exhibit 3 are the administration documents to include the case summary, previous board orders, property appraiser, and tax collector records. Exhibit 4 is the affidavit of posting and a copy of the sign. Exhibit 5 is the affidavit of prosecution costs. All the photographs and exhibits that were given to the violator are exact copies of what is being presented to the board. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violation and notice of hearings are sent return receipt requested in first-class mail. And please accept all exhibits into the record as evidence.
Thank you, Bobby. You'll do so?
Yes, ma'am.
Okay, so we have had contact with the owner by phone. On May 14th, I did the initial inspection. The trailer was parked in the front yard, and the small excavator was parked in the driveway. So on May 17th, the repeat violation notice of hearing was mailed, and the postal tracking states it was delivered, left with an individual. On May 20th, we received an additional complaint. I received a voicemail stating that the commercial trailer was parked in front of the residence again. On May 21st, I conducted a reinspection because the owner had called saying that it was ready in the afternoon of May 20th. The trailer and excavator were not parked in the front when I did the inspection. On May 28th, the sign was posted and an affidavit of posting was signed. So basically, we did this case not long ago, and the reason I had established it was because this has happened multiple times before where it was there and then it wasn't there, it was there and wasn't there. So I had a feeling it was going to come up again. Anyway, so this is just a picture of the trailer. They can park the trailer behind their fence, and that's no problem. And just a picture of the small excavator in the driveway. And that's all I have. When I went out again, they both had been removed. So what I'm requesting the code board members is to find the property in violation of City Code 42.00 for the parking and storage of recreational vehicles, which the trailer falls under that definition, from the day of the initial inspection, May 14th, and in compliance on May 20th. And that concludes my testimony.
And previously, no fine was suggested or anything?
They were in compliance when I brought them to code board to establish that code, so no fine was established, and it was in compliance when it came to code board.
Anybody like to make a motion?
I move that based on the testimony, evidence, and facts presented by law that the respondent was in violation of Section 42.00 of the Tarpon Springs City Code from May the 14th until May the 20th, and a fine of $50 a day for 6 days is $300. In addition, I move that the city be awarded $117.50 for the cost incurred in prosecuting the case.
Second.
Can I ask a question?
Yes.
Oh, what was the fine before?
There wasn't one.
I thought it was a repeat violator.
They were in
Am I missing?
compliance when it was established for the violation, so there was no fine assessed.
Okay.
It was seconded. Bobby, roll call, please.
Mr. Stammes?
No.
Ms. Porfirio?
Aye.
Mrs. Telliar?
Yes.
Mr. Weeks?
Yes.
Mrs. Archer?
Yes.
Ms. Wade?
Yes.
Your motion carries.
Affidavit of noncompliance, item number 20-800000653, 521 East Morgan Street, Kirk Jones.
I move that based on the testimony, evidence, and facts presented by law, that the respondent failed to timely comply with the board's prior order within the time prescribed, and awards the city $176 for the cost incurred in prosecuting the case.
All approved? All in favor?
Aye.
Aye.
Who was the second?
Mr. Perfidio.
Okay. Got it. Thank you.
Thank you.
I think Mr. Perfidio.
Got it. Thank you.
Any opposed? Final item, affidavit of compliance, item number 8, which is 20-800000754, 603 Sugar Mill Road, Robert McCulloch.
I move to accept the affidavit of compliance and to award the city $178 for the cost incurred in prosecuting the case.
Second.
Mr. Perfidio seconded that one as well. All in favor?
Aye.
Aye. Any opposed? Is there any old business? You have 2 sets of minutes that were given to you from our April and May meetings. Did anyone need to make any corrections on those? If not,
I move that we accept them.
do we have a second?
Second.
Okay. All in favor of accepting and approving the minutes?
Aye.
Any opposed? Do you have any other business you need to add to the
No, ma'am.
agenda?
Thank you.
Any from the city? Otherwise, okay. Then we're done. Meeting is adjourned. Thank you.